welcome to Legally Speaking with me, Tarun Nangia. This is part 4 of our series on the Prevention of Money Laundering Act. And we are joined by eminent jurist, a leading lawyer in the Supreme Court of India, Senior Advocate Parag Tripathi. Good to see you, Mr. Tripathi, and thank you so much for your time. And at the outset, I have to first say that if investment in India has to continue coming, if foreign companies have to see India as a place to invest, they always look at our laws. And why is this important? Because laws and how strict the laws are and what is the risk that you run if you run afoul of the law, how much time would you be in jail? Those all things also figure in the mind of investors when they put in money in a country. And that is why the Prevention of Money Laundering Act is an act which everybody studies, because there are these cases filed. But what is the risk of incarceration? That is also discussed. But we'll get into this in a detailed way with Senior Advocate Parag Tripathi. At the outset, you've seen this case play out in the courts of law. There has been a judgment by Justice Khanwilkar and the bench. In about the first 2 minutes, can you give me an introduction of this issue and concerns in the investor community?
You see, the whole problem which arises under the Prevention of Money Laundering Act is that the act, though, was enacted for a laudable objective, which was to bring back monies back into the Indian economy, which monies were the proceeds of crime. And the crimes or the linked criminal activity from which these monies was derived was to be set out in schedule of the act. So that was known as the predicate offense, and money laundering was utilizing the said ill-gotten money and passing it off as if it is not tainted money. That is the gist of the offense. The problem is, and I think the fundamental problem is the question of the status of an accused and his ability to secure his freedom by bail. That is the crucial issue which affects the business community. And it is not, Tarun, merely a question of foreign investment. It's a question also of continued further investment by Indian industrialists, because many high net worth people of the in that category of industrialists and entrepreneurs have shifted base out of India. So this is a very important aspect where a perception should be clearly made and given that the idea of the PMLA Act is not that the process is the punishment, and that the exercise of power under Section 45 to refuse bail and the corresponding activity or action of arrest is not done as a matter of course, but only in cases where it is required and for the minimum period for which it is required.
Because for the benefit of viewers, because you brought up Section 45, which is the twin condition for bail, could you give us a little bit of information on that section in the next 2 minutes or so?
You see, section, as a general rule, the whole criminal jurisprudence proceeds on the basis that a person is entitled to his innocence unless proved otherwise. And that runs into bail jurisprudence also. As a general rule, once investigation is over, a person would certainly be enlarged on bail unless there are reasons, serious reasons to the contrary. Now here, by virtue of Section 45, the whole process and jurisprudence is inverted. I'm not saying that the Parliament can't do it. It has done it, for instance, in Narcotics Act, etc. But the general rule that bail will be given and jail is an exception for an under trial. We are not talking of convicts. We are talking of under trials, particularly under trials where investigation is over. Now, Section 45 puts these twin conditions that one, you will give notice to the public prosecutor. And if he, upon notice, comes and objects, then the court will have to be satisfied that there is reasonable belief which the court is entertaining that the person who's accused of the offense has not committed the offense. And if he is enlarged on bail, he will not commit a further offense. Now, these are onerous conditions. Now, what makes them more onerous is, and that's a matter of great concern, what makes them more onerous is that the consequences that you remain in jail even after investigation is over. And that to say that under 436A of the Criminal Procedure Code, you can get, once you spend half your time of the sentence which could have been awarded to you if you were convicted, and then you can get normal bail, really doesn't answer the problem. Because if a person is wrongly arrested and he is eventually found not guilty, either because he is honorably acquitted, or if there is no credible evidence to convict him, he has lost out almost everything. Because as you know, that there would be attachment of property. If the property is a controlling share or stake in a company, then that will be attached. The voting rights will go to the government. So therefore, everything in the life of that person so arrested is completely brought to a standstill. And that is really the concern of Section 45. In the earlier judgment, which you had referred to, of the Supreme Court, where the Supreme Court had struck down the twin conditions, but on basically two issues. One, that in most of the acts where such twin condition is there, like earlier TADA, UAPA, or Narcotics Act, the offense complained of had to be an offense under that act. Whereas in Section 45, in its original avatar, it was an offense, a scheduled offense, which by definition was not the offense under the PMLA Act, but what is called as the predicate offense. So that was one very important aspect. And that is one of the reasons it was struck down. And the second reason was that the distinction of the term of sentencing can't be determinative on applying the twin conditions. Now, both of them by amendment have been taken away. So both these infirmities have been taken away. But the fundamental question remains that arrest has to be made not as a matter of course. And even once it is made, it should be at the administrative level, at the PMLA administrative level, be limited for the period strictly necessary. Once that happens, then things will even out. And added to that, as I said, is the problem of the ECIR, which is not like an FIR, but ECIR, which now the Supreme Court has held. Of course, the issue is now sub judice again, because notice has been issued in review, is that ECIR is an internal document created by the PMLA.
But we will come to ECIR, but I want to ask you these things. There is a lot of concern among industrialists and businessmen among Section 45, because they say that if I am held guilty by the court, you put me in jail.
Yes.
But if I'm not held guilty by the court, and if I've been accused of a certain case, then why the judge is forced to record a finding that I may be innocent? So without the trial being conducted, how can the judge record a finding that I am innocent? Do you think that is placing too much of a burden on the judge to give the accused bail, that the judge should feel that he is innocent before even the trial has been done?
I think yes, and for an additional reason. One is the reason which you articulate in the question itself. But remember, Tarun, when it comes to conviction, a conviction is not refused only on the ground that the judge is satisfied that the accused has not committed the offense. That is what is called honorable acquittal. A conviction would also be refused if the prosecution is unable to establish beyond reasonable doubt that the accused has committed the offense. This second limb, which is vital in giving acquittals, so many of the acquittals, if you look up the history of acquittals, by far the largest number of acquittals are because the prosecution has been unable to prove its case beyond reasonable doubt. It's not an honorable acquittal. So that benefit doesn't inure at the stage of bail. So the rule, therefore, is that getting a bail is well nigh impossible. But getting an acquittal is very, very possible because the percentage of success in conviction is quite low. So there's a mismatch here which has to be corrected.
I want to ask you something. If somebody has committed a fraud and earned 1 crore rupees, but he keeps it with himself, can he be booked for money laundering? Or that money has to be projected as untainted by converting it into a house or some other? Only then can he be booked.
Tarun, on both scores. Possession is also the offense under Section 3, and passing it off as untainted property is also an offense. So there are both aspects of the offense. Possession of proceeds of
I
crime.
want to ask you this also because there have been some people who've been advocating that if you have committed a fraud and acquired 1 crore, is that an offense of section 420 IPC, which is cheating, or is it an offense in the Prevention of Money Laundering Act also?
You see, you're right, but the offense under Money Laundering Act relates to proceeds of crime and 4 or 5 things associated with the proceeds of crime. Okay. One of which is concealment of the proceeds of crime.
Concealment also.
Yes. Concealment, possession, acquisition or use, and projecting it as untainted.
So you mean even possessing it is money laundering?
Absolutely. Absolutely.
So do you mean by this definition, every cheating case or a fraud case can be turned into a money laundering case possibly?
You see, the statutory trigger is the definition of proceeds of crime. Proceeds of crime contemplates that there is a criminal activity of the nature set out in the schedule, which we call broadly the predicate offense, like cheating, right? So 420 is mentioned in the schedule, IPC. Therefore, cheating comes in criminal activity that is a predicate offense. Any property derived or obtained, directly or indirectly, from such criminal activity is the proceeds of crime. So this is the definition of proceeds of crime. That triggers the offense of money laundering under section 3, which includes these things which you do with the proceeds of crime, which catches you in the net of the offense of money laundering. The first one is concealment. The second one is possession.
Can you give an example of concealment?
Concealment can be that I do cheating and I get 4 bars of gold and I hide them under my bed. Simple.
So that is IPC plus money laundering also.
That's right, because the predicate offense is of cheating. Here the offense is not of cheating. Here the offense is that cheating has created proceeds of crime. You have concealed those proceeds of crime. Now it so happens that you are doing both. You have also cheated and you have also concealed.
I want to ask you, somebody of your eminence, do you think that it is too wide a definition of money laundering? Too wide?
You see, the real question, Tarun, as we were discussing, is not whether this definition is too wide, but whether the schedule is too wide. If you limit the schedule to very, very specific predicate offenses like narco money, that is drug money, or terrorist money, or money of 1 or 2 other categories of such a nature that they completely shake up your economy.
Was that the intention? Was that the intention of the makers?
And that was apparently the intention, because it had gone to the Select Committee of Parliament. And originally there were only 6 acts which were there. So over time, it has enlarged itself. And now virtually it covers practically everything. You have things like SEBI, abolition of bonded labor, Juvenile Justice, Passports Act, Foreigners Act, Copyright, Trademark, Environmental Protection Act, Companies Act in respect of fraud and cheating, customs, then practically you have left out nothing.
So you can be booked. It's quite booked.
The only thing, and there are also technical problems that if you are supposing violating Juvenile Justice Act, how do you put a money value to it for proceeds of crime? So really speaking, these are serious violations. Nobody is doubting it. But these serious violations are not amenable to conversion into a predicate offense of a nature which will trigger action under the Prevention of Money Laundering. Money laundering is really meant if you have got, for instance, take African states, where a huge part of the money deposits in Swiss banks were from African heads of states or bankrupt economies. That kind of fraudulent.
It's very interesting, and that's why I want to ask you. In our definition of PMLA, you don't have to launder the money in a sense and project it as untainted. Even if you possess the money, we say that it's PMLA.
That's right. That's right. The section is broad enough.
And that is where the worry is. Do you think that is where the worry is?
Yes, because it says expressly, proceeds of crime, including its concealment, possession, acquisition.
And very interesting, from what today's discussion, I also find out that you don't have to launder and create a house or launder into any other asset.
Or
House,
protect it
land,
and maintain it. That's right.
even if you possess it, it is money laundering.
Even
So,
if you conceal it.
yeah, even if you, so if anybody has robbed a bank and robbed 4 gold bars and kept it somewhere hidden in his property, that also becomes an offense of money laundering. That's a very interesting observation. I think that would also be a matter of concern for many. And I move ahead on the issue of attachment of assets. So if a person robs a bank of 4 gold bars and keeps it with himself, first he's charged of robbing under, under the section of the Indian
That offense, some other court will take cognizance.
That other court. Then the PMLA will come and the enforcement directorate will investigate him.
At
Then
two
he will
levels.
go, and then he will go to jail, and he will not get bail easily.
That's right.
Now, if it is found out that he was not present in the city when the bank was robbed, so then he gets acquitted in the first offense.
That's right.
Does it mean that the other offense of PMLA also he gets acquitted? Is
Yes.
that
After the latest judgment of the Supreme Court, they have made this clear, though of course it's under review on other issues.
Yeah.
If the predicate offense is found to be innocent or is not found to be guilty, then of course the PMLA offense will not survive.
I want to ask you one more. Attachment. If somebody's bungalow is bought at 10 crore and now it is at 100 crore, can ED attach it at a value of 10 crore or 100 crore?
That's a neat question, because the question is, if it has been bought by the proceeds of crime, take a case where a bungalow is a very good example, but take a case where I take 10 crores as proceeds of crime and put it in a bank in an FD. Can I say that the interest which I have earned on the proceeds of crime, take a case where it is narco money. Don't take a case where it is, say, violation of cheating or something. Supposing it is narco money. Can the accused say that the interest on the narco money is not proceeds of crime? The answer has to be in the negative. But if the scenario changes, and if it is a cheating offense,
and it is not a narco money,
and more importantly, if you have a hybrid, that is, property is worth 10 crores, 4 crores of cheating, your money you are putting, 6 crores is your own money from legitimate sources, what happens then? Does it go on a pro rata basis? But Tarun, these are all issues which can be answered on a case-by-case basis, because that's how the common law system develops. What is troublesome with PMLA is the very strong power under 45, which has, in a sense, reversed the bail jurisprudence by saying that the court, what is required is not the court to say that at this stage, do I think it will result in a conviction? Because there is no investigation at this stage. So how can the court examine that issue? So court has to come to a conclusion without there being any investigation that the gentleman who is accused, or the fellow who is accused of the offense, has not committed the offense. That, I think, is I
want to ask you a linked question.
Yes.
If a businessman is arrested and put in jail, and the complaint against him, which in ED parlance is the Enforcement Case Information Report or the ECI, if I don't tell the lawyer of the complainant under what charges have I arrested him, then how the lawyer will defend the accused?
You are absolutely right. And I'm reminded of a very nice couplet of Munir Niazi, which actually answers what you are asking me, which is, Kisi ko hum apne amal ka hisab kya dete? Compliance ka hum explanation kya dete? Kisi ko hum apne amal ka jawab kya dete? Sawal sare galat the. Jawab hum kya dete? So that is the problem. When I don't have the ECR, now this is sought to be answered by the recent judgment of the Supreme Court, which I said is now in review, by saying that, look, the grounds may be made available to you when you file a bail, there may be an answer. And to say that ECR may have some other sensitive information, well, if there is a sensitive information, you can redact that part of the information. It can't be that the information is sensitive enough for you to put it in the ECR, but will not be made available to the accused where he has to prove his own innocence. Therefore, this is a double whammy, and I'm sure this requires a serious reconsideration.
Supreme Court will consider that this law, which allows you to put people in jail without they have been held guilty by the court of law. This is something that the court will look at seriously.
Historically, laws have always permitted people to be arrested pre-investigation, during investigation, post-investigation. So this is frankly not something unknown. The question is of limits. The whole jurisprudential debate is that you have to have limits. It can't be an unlimited power.
So you mean, are you taking the power out of bail out of the court's hands in PMLA? In a sense.
Effectively, yes, because what you're requiring the judge to decide or to prima facie find is a finding of honorable acquittal. That I am reasonably satisfied, and this fellow will not have the benefit of knowing what is the real case against him. Even in a normal show cause, when you sack an employee, let us say for gross insubordination, you tell him that these are your charges. Because unless you know your charges, how do you defend yourself? But
I want to ask you a follow-up question because of this. You would have seen law develop in your long career as a lawyer. There are ups and there are downs. Do you think this is a process from which we'll evolve beautifully and sense will prevail eventually?
You know, there is a whole theory of Hegelian dialectics. And that theory is thesis, counter-thesis, and synthesis. So you come up with an explosive idea, which is frayed at its edges, right? So then you have another idea, equally explosive, which is also frayed at the edges in a different way. And then there is a synthesis where you merge the two and move on. Take the case of basic structure. The first judgment was that any law constitutional amendment is just a law. It can be struck down as violative of fundamental rights. Then came basic structure. No, it can't be done, obviously. But then you said, no, there is a basic structure which is beyond. So the same way, I have no doubt that there will be changes. There will be this synthesis, which is very badly needed in order to rectify the somewhat draconian powers, which in my view have been unnecessarily given. You can have, actually, there is no reason why Parliament in its wisdom can't divide the schedule into Part A and Part B. Part A can be those original 6 offenses or 5 acts like narco money, terrorism, where you apply 45 in its full rigor. And Part B can be those where you have, if you must have them, Customs Act, environmental protection, trademark for heaven's sake, where the requirement of 45 will not apply with its rigor.
That's I think my takeaway from your show with you. This is a very fine point which you made. I think everybody will appreciate when you said that you divided into 2 schedules. That's what you said?
Yes, because see, ultimately, what is Article 14? Article 14 is not treat everybody equally. It's not take ser bhaji, take ser khaja. It is you treat equals equally and unequals unequally. So divide your schedule into making 2 groups, so which are not equals. Narco money cannot be treated as equal to violation of environmental law or violation of trademark rights. So divide them into 2 separate classes and then treat them separately. Treat narco, treat terrorism separately. You won't have voices of dissent there at all.
That's a very interesting point. I hope the viewers, eminent people in the legal fraternity also hear this opinion that you have put forward. It's a very interesting
Tarun, this can even be brought a judicial interpretation. Of course, it requires some pushing there, but judicial interpretation can be that, look, 45 in its rigor is really meant to go for the truly serious and heinous offenses under acts of that nature.
Which means you said the true intention of law was to nab people dealing in terror, gun running, and drug money. That is what you say that
which can completely destabilize your economy and bring that money back.
Yeah. So thanks for giving that interpretation and sharing your, in a sense, analysis of the whole Prevention of Money Laundering Act. This discussion was essential and also comes at a time when the PMLA judgment has been challenged, is under review. And of course, there is news in the market that there will be more review petitions filed against this judgment, and the court in its wisdom will decide. But I would like to thank you for your time. Thank you for analyzing it beautifully for us and sharing your view on the PMLA. We will request your time again on this issue, but that's it for now. Thank you so much. And thank you viewers for tuning in.
Thank you, Tarun. Thank you.
For more such videos, subscribe to the NewsX YouTube channel, hit the bell icon.